Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today we're going to be providing another installation into our U.S. Constitutional Amendment series going on number 23. So if you haven't gone back and watched 1 through 22, I would encourage you to do so because I'm sure it goes without saying that understanding the U.S. Constitution in its totality will be highly advantageous and beneficial to your knowledge when, not if, this ever-growing hostile lawfare state comes to harass you, your family, or your property. So without further ado, let's just go ahead and jump on over to the U.S. Constitution. We're talking about a consequential amendment, but one that doesn't necessarily pertain to you on an individual basis by a day-to-day basis, or on an individual level on a day-to-day basis. Amendment 23, passed by Congress June 16th of 1960, ratified March 29th, 1961, is talking about the voting rights of the District of Columbia, Washington, D.C. If you know much about Washington, D.C., you would know the founders intentionally segmented it from the other states. Why? They said, in instances like the Federalist Papers, the Anti-Federalist Papers, in their personal letters, and their publications, pinnings, everything like that, this region was dedicated to be the seat of government, to be the capital of the Union. And because of that, it could not vote in its own election because it doesn't represent anybody. It's not supposed to have residents. It's not supposed to have citizens because it's not a state. It's not sovereign. It's not independent. It's not unique. Its identity entirely depends on the formation of the Union, on the Union's existence. For example, if the Union disbanded tomorrow, all of the states would still retain their identities. All of the states would still have their own constitutions, their own legislatures, judiciaries, and executives. Washington, D.C. would not exist anymore. The entire reason that region was segmented from the East Coast states was to give it an objective, unbiased, completely isolated opinion. A domain free of political affiliation, so that way the representatives of the states could fairly, peacefully, or diplomatically hash out the problems and provide legislation that was within the confines of the U.S. Constitution. The District of Columbia is not a state. That's understood. That's a fact. And if they're not a state, they don't get to vote. Well, this amendment says otherwise. And it was a very scary amendment. It was a very concerning encroachment because, again, D.C. getting the right to vote is a step towards making D.C. a state, and that's a big problem. Section 1 says, the district, referring to Washington, D.C., the District of Columbia, constituting the seat of government of the United States. Where's the seat of government? It's in Washington, D.C. Shall appoint in such manner as Congress may direct a number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state. Even in that amendment, it admits D.C. is not a state, which means they don't get to vote. The reason the states have the authority to vote, retain the power to vote, is because the Union was formed for their benefit. D.C. doesn't get to vote because D.C. has never been and never will be a state. It's not represented. It's not represented because it's not a state. It doesn't have an identity exclusive of a union. Texas, sovereign. Missouri, sovereign. Kentucky, sovereign. Ohio, you get the idea. Washington, D.C. is not a state. It's not sovereign. So it's not being represented by the general government, by the union government, because it's not part of the union. If it were a state, but in no event more than the least populous state, And they shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state. So they're not a state, but we're going to give them the powers of a state regarding elections. Yeah, that's a horrible idea. And they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2 says the Congress shall have power to enforce this article by appropriate legislation. So let's go ahead and read through it just because I think it's pretty layman, pretty easy to understand. The reason it's so detrimental is because if you have the center of government, and you can look across any of the 50 states, the founders pointed this out frequently. The founding generation pointed this out frequently. The center of government is going to be the most corrupt place, which is why it shouldn't be represented, gosh darn it, represented by the government, because it's the most corrupt place. Look anywhere. Look at any capital. That is going to be the most corrupt, which is why it shouldn't be voting on its own affairs. Which is the very reason the District of Columbia is not a state. So why are you giving it state authorities? Why are you giving it state powers, like influencing elections? So let's read it one last time. Hopefully you understand just how devastating this amendment was and why it should immediately be overturned. Let's read through it one more time and then we'll go ahead and wrap it up. So Amendment 23, Section 1, it was ratified in 1961, excuse me. Section 1 says, the district, talking about the District of Columbia, constituting the seat of government of the United States, shall appoint in such manner as Congress may direct. A number of electors of president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of amendment. Section 2 says the Congress shall have power to enforce this article by appropriate legislation. Excellent. So if you have any questions about what's being stated in Article or Amendment 23, which is said plainly, but there could be nuances, there could be sections that you're concerned about, go ahead and post them in the comments, as well as if you have any questions about amendments or Articles 1 through 10 and Amendments 11 through 22, go ahead and post those in the comments. Also, if you have any topics you'd like me to cover in a future lecture, post those in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to fend off any sort of attacks, lawfare attacks, that will be waged against you, your loved ones, or your hard-earned property. Additionally, I hope you enjoyed this lecture, and if not, let me know how I can do better so I can best serve that purpose exceptionally rather than insufficiently. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you'll have a wonderful day, and I'm not sure what the topics for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so, again, to best serve that purpose of helping you. One last time, I hope you'll have a wonderful day, and until the next lecture, regardless of the topic, I bid you all farewell.